Hello friends, in this lecture we shall discuss multi-option questions related to legal and regulatory aspects of banking of JAIIB exam. So here is our question. The banking companies are required to preserve records of various transactions for a period prescribed by whom and under section which of Banking Regulation Act. So banking companies, they have to preserve their records for certain period for various transactions, and this period is prescribed by. Let us see the options. Option 1, central government, section 45Y. Central government, section 45Z. RBI, section 45Y. RBI, section 45Z. Friend, rules relating to preservation of records are notified by central government, and this is done as per section 45Y of Banking Regulation Act. Hence our option answer is A. So central government has the powers to prescribe the period for preservation of various type of bank records under section 45Y Banking Regulation Act. If on recommendations of RBI, a moratorium is imposed on a bank by the government, the total period of such moratorium can be extended by government not exceeding. Moratorium means restrictions imposed on a bank to repay back its deposits. So if those type of restrictions are imposed, the period can be extended on RBI's recommendation, but up to what extent? Let us see the option. Up to 12 months, up to 9 months, up to 6 months, up to 3 months. Friends, this period can be extended maximum by 6 months. Hence our answer is 6 months. So if on recommendations of RBI, a moratorium is imposed on a bank by government, the total period can be extended maximum up to 6 months. Protection is available to a bank under which section of NI Act for making payment of a check which is materially altered if alteration is not apparent. So which section of Negotiable Instrument Act provides protection to the bank if bank makes payment of a check with material alteration, provided alteration is not visible, alteration is not apparent. Let us see our options. Section 10, Section 85, Section 89, Section 128. Section 10, it relates to payment in due course. Section 85, it relates to payment of a check with endorsement. Section 128, it relates to payment of a crossed check. Section 89, it relates to payment of a check with the material alteration. So section 89, subject to certain conditions, provides protection to the paying bank if a check with the material alteration is paid. So our answer is C. A bank receives a check from its customer for collection which he had not crossed. Bank collects the check by putting its own stamp for the purpose of collection. Later on, it turns out to be a case of conversion, that is a fraud. So the bank receives a check from the customer but for collection, but customer has not crossed that check, and bank by putting its own stamp for the purpose of collection collects the check. Later on, it is found that It was a case of conversion. Conversion means this check related to some other party and collected from account of some other party. Let us see the options. The bank shall not get the protection. The bank shall get the protection as crossing is not an essential condition. The bank shall get the protection since at the time of collection the check was specially crossed. The bank shall get protection if check was a bearer check. Friend, in case of conversion means when check relating to a customer does not belong to him. So if check is collected for a customer to whom it does not relate, this is called a situation of conversion. And bank is protected if certain conditions are satisfied. And one of those conditions is the check should be a crossed one when it was presented for payment. When crossing can be general crossing or crossing can be special crossing. So when bank puts its own stamp for the purpose of collection, the check gets specially crossed. So in this case, since check was specially crossed at the time of collection, the bank shall get protection. So this protection will be available under section 131 Negotiable Instrument Act. Let us see next question. A contract of insurance is an example of. So insurance is also a contract and it is an example of what? A contract of guarantee, a contract of indemnity, a contract of guarantee or indemnity. None of the above. Friend, in the contract of guarantee, the guarantor gives guarantee to the bank, to the creditor, for non-payment by the borrower. In case of indemnity, one person gives a guarantee, indemnity, to another person for making up the loss caused for any reason. And a contract of life insurance or insurance, it is a sort of assurance, it is a sort of guarantee, indemnity, that the insured will get compensated if he incurs loss because of any reason. Hence, contract of insurance is example of contract of indemnity. A contract of insurance is an example of a contract of indemnity because the insurance company promises to save the person against loss caused by conduct of insurance company or third parties. If a bank guarantee is issued by a bank in lieu of customer's requirement to deposit a cash security or earnest money, so such bank guarantee is called. So guarantee has been issued in lieu of customer's requirement to deposit cash security or earnest money. So such a guarantee is a financial guarantee, a performance guarantee, a deferred payment guarantee, or any of the above. Friend, when guarantee is given against customer's obligation to deposit cash or earnest money, so such guarantees are called financial guarantees. Hence, this guarantee will be a financial guarantee. So our option answer is A. It is a financial guarantee because bank has promised to the beneficiary to pay if applicant fails to pay the cash security or earnest money. Which of the following parties in a bank guarantee are properly named? So there are various parties in a bank guarantee. Let us see the options. One is The borrower on whose behalf the guarantee is issued, he is called beneficiary. The party in whose favor the guarantee is issued is called applicant. The bank which issues the guarantee is called surety. None of the above. Friend, borrower on whose behalf the guarantee is issued called applicant. The party in whose favor guarantee is issued is called beneficiary. The bank which issues the guarantee is called surety. Hence, C option is the correct answer. So the party on whose request the bank guarantee is issued is called applicant, in whose favor it is issued it is called beneficiary, and bank is called surety. Hence our option C is correct. As per UCPDC 600, the negotiating bank gets a reasonable period, maximum how many days, after receiving the documents from beneficiary to make the payment. Under UCPDC, the payment is made by negotiating bank after checking the documents received from the beneficiary. What is the maximum time period? Let us see the option. 5 working days, 5 banking days, 7 working days, 7 banking days. Friend, as per provisions of UCPDC 600, the negotiating bank has reasonable period which is restricted to 5 banking days. Hence, our option B is the correct option. So the negotiating bank gets maximum 5 banking days to pay or refuse to pay. Similarly, the issuing bank after receiving document from negotiating bank also gets maximum 5 days to check the documents. Well friends, if you feel that you have been benefited by this lecture, you have the option to have our study material for mock test, for hard copy, soft copy, e-books, video DVDs, JIB, CIB, etc. Thank you friends for watching this video.